This is Top of Mind, the Dr. Patrick Slowinski Show.
All right, well, good evening, everyone, or whatever time of day it is when you actually watch this. This is Patrick Slowinski on Top of Mind. It's my honor tonight. We've got a lot going on in the world, and one of the things that is really top of mind for people are the recent Supreme Court cases, what that means in terms of the Trump administration, what that means in terms of birthright citizenship, what it means in terms of lawfare. So I'm bringing on a friend of mine, Eamon Earls, who is an attorney here who lives in the District, Maryland, Virginia area, which we kindly call the DMV. And he's going to come on with his expertise and give us a take on what this really means. There is a lot of spin out there in the spin zone about who really wins from these recent decisions. We also had some decisions in the summer that conservatives weren't too thrilled about. We might talk about that. And then the overall theme of lawfare. So without further ado, I'll let our guest tonight, Eamon, introduce himself a little bit, and then we'll get started talking about the Supreme Court decisions that are historical. Eamon.
Well, Patrick, thank you so much for having me on the show today, and it's a real pleasure to be with you. I know I've been eager to be a part of your podcast, and so actually getting a chance to join you tonight and to talk about stuff that's near and dear to my heart, the goings on at the U.S. Supreme Court, is a real pleasure. Now, of course, we're at a very interesting moment in time, and I'm very fortunate that in the work I do as an attorney, I get a chance to work on many aspects of some of these evolving kind of leading edge of the law areas here in the U.S. One of the things that's really been an honor for me is to have a chance to work on constitutional matters in a lot of the work that I do as an attorney. So I have a chance to represent clients, essentially working to support their rights under the U.S. Constitution for different liberty organizations that I've worked with. And so in that role, I have a chance to read a lot of the things that the Supreme Court, goes ahead and issues as decisions. And for myself, try to figure out how that all fits into the bigger picture of what's going on in the U.S., where our legal system's going, and what that means for the wider world.
Well, thank you. And a little bit about your law background. I know you have a law degree from George Mason University. And what kind of law have you been practicing?
Yeah, that's right. I had a chance to study law at George Mason University right here in Arlington, Virginia. So the heart of Northern Virginia, a stone's throw from Washington, D.C. I came to law school actually by way of sort of state and local government. I served 2 terms as a city council member in Massachusetts, getting to know how the U.S. federal system works at the lower levels, the local governments that really shape so much of our day-to-day of when the trash gets picked up, how the schools run, and whether the roads are full of potholes or not. And armed with that background, I made the switch to law school and have had a chance to work most of my career so far in essentially constitutional law, but with a dash of civil litigation and labor and employment law and kind of complex litigation thrown in on top of that. Because being pure constitutional law often means actually really being involved in a lot of other areas of legal practice too.
Excellent. Well, let's kick this off with a clip, producer Victor in the back there, of President Trump talking about 3 recent court cases, but one in particular that he drew a lot of emphasis to, and it's one that most people did, and it's the influence that judges have on injunctions, on interstate injunctions, and so national kind of injunctions where a court judge can weigh in. But let's see what about the victory lap that President Trump is taking for that decision. Then we'll have you analyze that for us.
Has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers. It was a grave threat to democracy, frankly, and instead of merely ruling on the immediate cases before them, these judges have attempted to dictate the law for the entire nation. In practice, this meant that if any one of the nearly 700 federal judges disagreed with the policy of a duly elected president of the United States, he or she could block that policy from going into effect or at least delay it for many years, tie it up in the court system. This was a colossal abuse of power which never occurred in American history prior to recent decades, and we've been hit with more nationwide injunctions than were issued.
All right, we'll go ahead and stop there. But Eamon, I think the president misspoke a little bit in the very beginning. He meant that federal and district judges were stopping the presidency, not the Supreme Court. But he got right to the heart of it. Go ahead and address that. But before you do it, if I'm a Democrat or a liberal or someone who doesn't like President Trump, the first thing I'm going to say is, well, the Republicans do that all the time. So first address what President Trump is talking about, and then this use of judge shopping to get the kind of injunctions that you want. Is that a one-party thing, or have been both sides been guilty?
So maybe to kind of frame this a little bit for folks listening, whether they're here in the US or internationally, to take a step back, it may help to just kind of explain what we're talking about in terms of injunctions or universal injunctions. The US is obviously a federal country. It's 50 different states that function in many ways as their own small republics with their own separate judicial systems, their own separate state governments, their own constitutions, plus territories and the District of Columbia that function sort of like states in their own right. Of course, the US has a very powerful federal government, and both the federal and state governments are shaped by the US Constitution, which was originally created in the late 1780s and pretty much fully ratified by the states by 1791, including the Bill of Rights, the famous First, Second, Third, Fourth, Fifth, Sixth, Seventh, Eighth, Ninth, and Tenth Amendments that form many of the core civil liberties in the US Constitution. Many people are less familiar with sort of the ingredients of the Constitution as it was originally created. These are the articles of the Constitution, essentially the different branches of government, each spelled out, plus the relationships between the federal and the state governments. And here I draw folks' attention to Article 3. Article 3 of the original unamended US Constitution is what sets up the federal judiciary. Now, of course, those states, they all have their separate court systems that deal with many different court cases, disputes between neighbors, criminal cases for most crimes, divorces, things like that, wills and trusts, all these common matters get dealt with very often at the state level. But the US has this other expansive nationwide system of federal judges. Currently, there are in the realm of about 800 to 900 federal judges, about 600 to 700 of whom are federal district judges, the lowest echelon of these Article 3 federal court judges. U.S. Federal judges are very, very powerful. That's a thing that I think our listeners should really understand. They're very, very few in number, and they wield tremendous power, even though they only hear about 2% of all court cases in the U.S. Judges are named by the president and voted on by the U.S. Senate and serve for life. So if they want to, they can serve till they're 115 years old if they make it that far. Throughout that entire time, they're authorized to make decisions that come before those courts, and in some cases, make what are called equitable decisions. There's an old distinction in English and by extension American law between legal matters that tend to be about things like damages or the specific legal outcome of a case, and equity, which is essentially issuing things like injunctions, orders to do or not do certain conduct. For almost 200 years, these questions about damages and these questions about equity and these special orders have been sort of mashed together and combined as one thing. However, some of the issues have come up with injunctions and how expansive and extensive they can be. So that's what President Trump's talking about in his press address right there, is the Supreme Court's recent ruling in Trump versus Casa, a case that, as of 3 days ago, has gone ahead and blocked nationwide injunctions going forward, basically holding, with the majority of the Supreme Court reaching this conclusion, that nationwide injunctions issued by a single federal district court judge, or perhaps even by the Supreme Court itself, simply weren't something that was known in American law way back when the Constitution was first adopted, and go far beyond the powers that federal courts actually have.
Right. And I guess my second question was, is this just a tool that Democrats have used because they have a majority of those federal district judges? Or tell us a little bit about judge shopping, right? So can you go to different parts of the country, to a blue state if you're a Democrat president, or to red states if you're conservative, and get the kind of decisions that you want through this judge shopping? And I think that's what people are looking at, that they want that this stop no matter who's president.
So the short answer to the question is that there definitely is a lot of what's called forum shopping, of people being, essentially strategic in where they file a case where they think judges will be more favorable to them. And this happens all across the political spectrum, and even among private sector attorneys in the U.S. representing companies or organizations where they think they're going to get the most favorable result. In practice, of course, it can be more difficult than that because an essential part of Article 3 of the U.S. Constitution is this idea of standing. It's not expressly said in there, but it's a very common idea that's important for our listeners to kind of understand, is the idea that you need to have, a concrete, particularized injury specific to you and not just a speculative problem that you're concerned about to actually show up before a court and request a judge to do something for you. So a lot of fights these days in the law come down to questions of standing and sometimes questions of venue. Is this the right place to bring this? And are you the right person or organization to bring it? Especially in cases involving the federal government, though, because obviously it acts nationwide, it's much easier to get standing a lot of times and to file where you'd like and to go ahead and race to get one of these injunctions issued nationwide by a friendly judge by running straight down to the courthouse in San Francisco if you're a Democrat, or racing to some small district court in Texas if you're a Republican. So there's sort of a certain degree of this on both sides of the spectrum.
Exactly. And before we get into a little bit of the nuances there of what just happened, that President Trump is rightly happy about. Producer Victor, let's take a look at what CNN said about President Trump's victory lap.
President Trump just addressed a monumental Supreme Court decision poised to redefine executive power in this country. He personally thanked the justices who ruled in his favor, the 6-3 decision sending shockwaves across the country as it limits lower courts' ability to block president's executive orders by using a nationwide injunction. This case specifically revolved around whether President Trump could enforce his ban on birthright citizenship. And the decision now clears a path for him to move forward with that, at least for now, even though the vast majority of constitutional scholars say it is unconstitutional. CNN's Kristen Holmes is at the White House. Kristen, you're listening to the president there, clearly taking a...
I think we can stop there, Victor. So definitely in this court case, I believe that in CASA, this was about birthright citizenship tangentially, right? But the court did not make a decision on whether the 14th Amendment is going to be revisited and perhaps struck down. At least our interpretation of the 14th Amendment could be changed, which means that those who end up in the United States on any kind of territory that would grant them citizenship by just being born here, whether that would be revisited. I personally think that's never going to happen. But that's definitely what I think you see CNN doing there, is jumping onto that part, because I think they know that that's a higher mountain to climb for President Trump and the administration to actually get that overturned. And so I think that's why they're jumping to that. So just your thoughts there about the spin on both sides for what this court case really means. And it was Trump versus CASA, right?
Mm-hmm. Yeah, and I think it's very interesting always seeing spin from both sides of things. A bit of a breathless take from CNN there, given that this case didn't address the merits. Essentially, it didn't go to the question of whether or not birthright citizenship is actually in the 14th Amendment of the U.S. Constitution or not. That's a question for another day, which I'm sure there will be plenty of future litigation about if the Supreme Court wishes to hear it. In this particular case, this was just limited to the attempt to have a nationwide injunction against President Trump's birthright citizenship executive order. And, I think it'll be very interesting, in the future, if the Supreme Court decides to hear that case, quite how they'll rule on it. I'm probably with you in that I think that the current composition of the Supreme Court would probably hedge and not rule that, even though there's actually, contrary to what CNN says, it's a bit more of a split case on the birthright citizenship question. If you look at the specific wording of the 14th Amendment and who it says is a citizen of the United States. But of course, a lot of that comes down to the final say of the 9 people on the U.S. Supreme Court, which comes down very often to personality more than the specifics of the Constitution itself.
So I spent time during my one of my master's degrees on the in the Navajo Nation on the reservation there, and I was shocked to find out that Native Americans did not automatically get citizenship, even though they were born on the land that became the United States. That came later on. And so that had to be dealt with. So I'm thinking, if that isn't, if Native Americans didn't automatically have the kind of citizenship because they were members of a tribe at the time, they had to become naturalized and then have the right to vote. Then why do people that just end up here and have a kid here automatically have that right? So I think there are a lot of rooms for, I think, healthy discussion on whether someone who gets here, and what about citizenship tourism, right? That's a real thing. One of the things I did as a foreign service officer, our very first tour that we do, we have to do consular work, which I think is a great thing. And you often get to decide whether people get visas or not. And you would see people, you didn't know for sure if they were pregnant, but sometimes they let it out by accident, or you somehow figured it out. And then you had to decide whether their intent was actually to go for tourism or to stay there and have a baby. And I think because there's a whole bunch of things that go with that, welfare and does this person or their child become a ward of the state? And I think a lot of US citizens don't know that the consular officers out there actually try to determine whether these people are going for what intent. And then when they get to the actual border, the Customs and Border Patrol officers do the same thing in their interviews. Just because you have a visa doesn't mean you're going to be let in, even if you come by air travel. So I think those are interesting things. I want to play you one more clip. The Young Turks, gotta love them. So the Young Turks have their take on it too, and it's interesting to see them not so happy about the recent court cases.
I think that this court is calling President Donald J. Trump their daddy. I really do.
Well, this was a big one, wasn't it? This was a big decision. An amazing decision, one that we're very happy about. This morning, the Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour.
Okay, so Grandpa's train of thought fell apart a little bit at the end there, but it is a big day, not only for President Donald Trump, but any aspiring autocrat who wants the power to trample not only what Congress is constitutionally obligated to do, but the Supreme Court, lower courts as well. And so they announced earlier today that what he wants, which is an end to a lower court ruling that was temporarily blocking his bid to end birthright citizenship, he got it. And he got it not only in the birthright citizenship case, but effectively, it could be that for all cases in which lower courts try to even temporarily block Donald Trump's executive decrees, they won't be able to do that in the future. And that has only like the widest of implications.
They thought it was a disaster. And so if you're a diehard liberal that can't stand anything about President Trump or America First or Make America Great Again, you're lamenting a little bit just that the lower courts can't step in and basically overrule a president. Remind us again the first three articles of the Constitution. The third one you already talked about is establishing the judiciary, but tell us about the first, the second, and the third, and how they all kind of fight with each other.
Absolutely. So the first three articles, think of them as chapters in many ways of the U.S. Constitution. Pretty brief, a few hundred words each. These are some a little longer than that, but the first three articles are essentially the core branches of the U.S. federal government. So each article spells out one of the three parts of the separation of powers between Article 1, which is the legislature, so the U.S. Congress. Article 2 is the executive, so the U.S. president and all of the agencies ultimately created by Congress under him or her. And then Article 3, of course, is the federal courts, the judiciary. And so the U.S. has always been, from day one, from the moment the Constitution was ratified, a country founded on the principle of separation of powers. In practice, of course, balancing those three has proven more challenging, than perhaps the Constitution and its drafters had in mind. So today, there's in many ways an issue where we essentially have four or more branches of government all sort of vying with each other. And I'll explain what I mean by that. Beginning in the late 19th century, so about 20 years after the Civil War, with the passage of things like the Pendleton Act that created a professional civil service for the U.S. began to witness a shift from constant turnover of sort of at-will employees, between different administrations, where loyalists of one president would come in and then they would go and be replaced by other folks from the next administration. From the early 1880s onward, the U.S. began to have a large number of permanent federal bureaucrats who would essentially serve, with career civil service protections for a long period of time. Around the same time, the U.S. began to see a large increase in the number of agencies created by Congress, each beginning to do things that looked more and more and more like making law, which is supposed to be the purview of Congress alone. Today, of course, the U.S. has millions and millions and millions of words of regulations and associated documents created by all of these federal agencies that are really the law as it actually exists, often much more so than the actual statutes passed by Congress, which are also pretty extensive. So the issue we have currently is a very large federal bureaucracy that routinely has people who are not elected going ahead and making laws that then are often very difficult to change or modify, and gives Congress very little incentive to go ahead and change them. They can the buck does not stop with Congress, because essentially these agencies will be delegated a sort of general, like, fix this problem kind of mandate, and then be allowed to come up with all the rules and regulations from there. This is a huge issue because the federal government as a whole trends in a very left-wing or very institutional or bureaucratic direction that tends to disfavor people like President Trump or other would-be reformers from either the left or right who would like to change that system and do everything in their power to obstruct efforts to change policy that voters want. And so that's one of the real issues that's coming into play here. President Trump, more than many other presidents in recent living memory, has gone far out of his way to achieve reforms that he thinks his voters, who put him in the White House, want to see, and is often fought tooth and nail by agencies that are technically under his control, but essentially often act with sort of their own agenda when he wants to make changes, and then find themselves supported by outside nonprofit groups and law firms and things like that side with those agencies or have their own policy agendas that they want to push.
Yeah, and I think as a former federal employee, I mean, it's no secret to me that getting into federal jobs is very difficult. There's a lot of competition, but once you get in, it's very difficult to fire somebody for cause, and there's a lot of incompetency there. I think sometimes when you're trying to cut back, and we're just talking about federal employees here, one of the things that people are upset about is that President Trump would dare come in and do something different and say, do we really need all these people? And are they actually doing the jobs we need them to do? And actually taking a look at whether federal employees have to stay in the jobs just because of some kind of right they have. And it's interesting to me, the clutching of pearls and the gnashing of teeth or the wringing of hands that all the people have, when if those people tried to make it in the private sector for one day, they'd have a hard time. And so good for President Trump for looking at these things. I will say with this, in the context of our conversation tonight, is that all of that, what you just explained, is that lawfare concept, right? Using the Article 3, you talked about 1 and 2. And it's interesting that the first one is not the president, it's actually the legislature. And then the president comes in, but then Article 3 is supposed to be the objective arbiter in that. And I think that's where people have seen over the years, especially with President Trump, who has the largest number of challenges and injunctions of any president by these lower courts. And now some would say, well, that's because what he's doing is unconstitutional. Others will say this is lawfare. So we'll finish our clips tonight with the White House spokesperson here talking about Carolyn Leavitt talking about lawfare in the context of the recent court case decisions by the Supreme Court by SCOTUS.
About that, Jackie.
Thanks, Carol. What options does the president have to, he says he's going to follow court orders. He wouldn't defy a court order, but he's raised these concerns about these judges acting in such a partisan way. What option does he have to ensure that his agenda continues to move forward while this is ongoing and the judges appear to be trying to just block and delay and impede?
Well, you're right. They are trying to block, delay, and impede. This is lawfare. The president is no stranger to it. He faced it in his campaign, and this is a continuation of the lawfare that President Trump faced as a candidate, and he's now unfortunately facing as a president. Clearly, these partisan activists in the judicial branch didn't get the memo on November 5th when the American people overwhelmingly re-elected this president to continue with mass deportations. So White House counsel and the Department of Justice are working on this. They're appealing these cases, and we will continue to use the full weight of the White House counsel's office and the president's team of lawyers to fight this in court, because we know we will win, even if we have to go all the way to the Supreme Court.
So with that, I want to get back to, before we run out of time this evening and have such a judicial expert here with us, to talk about the other two court cases that conservatives are calling wins for the president as well. If you could just quickly review those other two cases for us.
Yeah, so there's actually been a number of different cases that have come down recently. If I'm referring to others than the ones you have in mind, just go ahead and correct me. There's been an interesting case that was resolved out of Montgomery County, Maryland, immediately west of Washington, D.C., which is essentially a free exercise case. So essentially religious freedom, religious liberty under the First Amendment of the Constitution, which guarantees freedom of speech, freedom of the press, freedom of assembly, and free exercise of religion. And so that's a very interesting one where essentially the Montgomery County school system has had essentially a mandatory LGBTQI plus, whatever their current acronym is, education program targeted toward young children, essentially like early elementary age, and in some cases even younger, that initially had opt-outs, but then became essentially a mandatory case. This Mahmoud versus Taylor is this particular case. There, the Supreme Court ruled in favor of parents who were concerned about this in Montgomery County from sort of diverse religious backgrounds, holding that they have free exercise reasons to opt their kids out of this. So that's certainly an interesting case. That's one of many we've seen over the last few years, continuing to expand religious liberty under the First Amendment after decades in the past, back in the 1960s, when it was very much sort of the opposite direction with how the Supreme Court would often rule on those kind of cases.
Right, and the plaintiff in that case is not a Christian, as many people think. Is a Muslim.
That's correct, as far as I know.
Yes, and again, it's a religion that has very strong feelings on certain moral issues that really parents should be at least have the option. Look, I think most people understand that there are some children that are in home situations where they don't have a lot of information that's helpful one way or another, and the school can be a funnel, if you will, for that information. Not a replacement for parenting per se, but you also have intact families or families that even single parent homes that do not want schools and school teachers with specific thoughts and ideologies making curriculum and then force feeding that to their kids. So for many of us, it just seems like common sense, but it's interesting that it's been a battle for parents to opt out of these classes for their children. And then the third case, if you could quickly.
Yeah, and sorry, remind me which of the cases you had in mind.
Is the one that I've lost the train of thought here, but it was those three that came out on the same day on last week. So those three.
You know, we've had such an influence. This is basically Supreme Court season for those listening. Supreme Court tends to issue a lot of its decisions right at the end of June every year, based on the previous year's term. So certainly some interesting ones this year. One that's perhaps a little bit more of a mixed bag is the Consumers Research case, which concerns the Universal Service Fund for the Federal Communications Commission, the federal agency that oversees electromagnetic spectrum and essentially how all radio broadcast or cell services work in the U.S. And that's a little bit more of a mixed bag. That's an interesting, actually, example of where you see some of the splits you don't hear about in the media with the Supreme Court. The way news reports on the U.S. Supreme Court tends to talk in terms of liberal and conservative, but that sort of misses the point. There's in many ways a 3-3-3 split of the 9 justices on the Supreme Court right now. There's the 3 liberal or left-wing judges. There are 3 judges who could probably be characterized as more institutional or perhaps more sort of Chamber of Commerce conservative, and then 3 who would probably be considered originalists, those committed to trying to understand the Constitution as it was originally adopted back in 1791 and during other periods of big changes to the Constitution in 1868 and so forth. And so this is why you get sometimes these decisions from the Supreme Court that seem really puzzling course, each of these justices has their own opinion, but you often get seemingly divergent results because of the three institutionalist judges on there who will sometimes side with the left and sometimes side with the originalists. And that was sort of what happened with the Consumers Research case, where the three more institutionalist judges who are described in the media as conservative, but folks like John Roberts, Amy Coney Barrett, and sometimes Justice Kavanaugh, they ruled along with the three left-wing or liberal justices that this program at the FCC, which is why many of our cell phone bills are so high, of essentially billing consumers to pay for expanding cell service nationwide, is constitutional. So six of the nine justices ruled in favor of this view. Three, the originalists, ruled against it, with essentially dissents in that opinion. And that's a bit more of a complicated issue. It'll be interesting to see how it plays out over the longer term. But it's sort of a mixed bag because, as written, it opens the door to government agencies taxing to give money directly without congressional approval to private companies, which is something that doesn't really have much support in the original Constitution, and seems like it might have opponents on both sides of the spectrum.
Right. And I guess the thing that most people would want, they'd want their justices to be completely objective and leave all of their political biases at home. That's impossible. I think Justice Coney Barrett gets a lot of crap, but I think she's trying to do that. And she does end up on in many conservatives, to the chagrin of many conservatives, over with the three other ladies on the justices on the court a little bit too often. And it's interesting that she wrote a very, I think, sharp criticism of Justice Jackson's opposition to the majority in this last one, which basically took away the national injunctions in a sense. And so that was an interesting case. The last case that I was thinking about was the age requirement to enter.
Yes, that's right.
Prove
So
your
this
age
is
to enter pornography sites.
free
On
speech.
the one hand, you protect children by doing that. On the other hand, you can possibly put people who are adults over 18 looking at that stuff, who have a right to look. Maybe they feel that their privacy is compromised. So there's kind of a battle there.
Yeah, this particular case is called Free Speech Coalition versus Paxton. This is Ken Paxton, the Attorney General of Texas, who was named in this particular case related to a 2023 law passed by Texas requiring age verification to go ahead and access porn sites. And so I'm very interested to see how this will ultimately kind of go from here. I haven't had a chance to read this particular case in depth, so I can't comment as specifically about it as some of the others. There's a perhaps more complicated debate about this than many people realize that has supporters really across the political spectrum, one way or the other. There are some conservatives who are thrilled about this because they see this as an opportunity to limit the ability of children to access porn sites with all of the can of worms that can be. And some folks on the left are concerned about it because they see it as a harm to individual liberty. But it is even more complicated than that, because there are certainly some folks in the free speech and liberty world who are concerned about what this precedent might mean for things later on. There's been an initiative currently blocked by the 11th Circuit Court of Appeals out of states like Florida, rather, to impose age verification for all social media sites. And setting aside the question of whether or not it's constitutional to have age verification for porn sites, I think it's a pretty strong case that age verification for internet sites in general is unconstitutional, because at the time of the founding, it's very clear that anonymous speech was protected in the way that American law is understood. I mean, for instance, the very understanding we have of the U.S. Constitution comes from people who were writing under pseudonyms. Folks like Publius, Hamilton, and Madison were writing the Federalist Papers in New York newspapers promoting the new Constitution under pen names because they didn't want to use their actual names. And the Supreme Court has regularly said that you do not have to reveal secret associations if it's for the purpose of speech, and organizing for lawful purposes and things like that, discussing with others. So I think if this principle were extended beyond the Free Speech Coalition versus Paxton case to age verification generally, which would mean identifying yourself to use any online service, that would be potentially problematic.
Yeah, and I think was it another Supreme Court justice that said, I can't really give you a definition for pornography, but I know it when I see it. And, I think it's a pornography issue. It brings up the morality issues in court cases often. The religion gets injected into the discussion. Morality gets injected into the discussion, and whether Article 3 if justices are actually morality police or not, one way or the other. Listen, Eamon, we have talked a lot. You have covered all the major cases this week and talked a little bit on lawfare. We appreciate you coming on the show, and we're going to invite you back again because I have a sense that there are going to be more important cases coming down the pipe.
Well, if there's anything we know for sure, it's that the world keeps turning, people keep filing lawsuits, so we'll have lots more to talk about. Thank you so much for having me on. It's been a real pleasure.
Thank you.
In a world full of noise, clarity is power. Stay informed, stay aware, stay top of mind.